And we're staying with the Supreme Court judgment on the PDP Labour Party appeals relating to our electoral laws and Nigeria's electoral system, the reasons behind the decisions of the justices and how it will play out eventually with Nigeria's electoral processes and the nation as a whole. And joining us to look at all of this is Mr. Yemi Candidate Johnson, a senior advocate of Nigeria. He joins us virtually. Thank you for joining us, Mr. Candidate Johnson. Joining us. Mr. Candidate Johnson. Joining us. Mr. Candidate Johnson. Joining us. All right, if you can hear me there, let's start off from that point. The judgment of the Supreme Court's come forward, and borrowing the words of the president to the German chancellor, he said the distractions are over. It is now time to change the negative narratives around Nigeria, move this nation forward. Let's start off from there. What's your take?
Well, the process of election is always contentious. It can be divisive, and therefore it's disruptive for the task which should follow an election, which is governing. And so I think the president is right. The electoral process having gone to its legal conclusion with the decision of the courts, the final decision as to the validity of the election, I think it's fair to say that the task outstanding now is to build Nigeria, to govern Nigeria, and to put its best foot forward.
So if your colleague, Mr. Falana, said something there, he said, you put it this way, the burdening of the courts, implying that the courts are overburdened with some of these things that can be settled outside of court. Let's look at a bit of history here. The U.S. president, former U.S. President Nixon, says that if his presidency was going to be decided by the courts, then there's no point for him going into it. That was before he became president eventually. But how did we get to this point where practically all the elections in Nigeria are decided by the court? Can we get out of that space?
It's a problem. In the UK, which was a colonial power in this country for many years, there has been one election petition in the last 150 years. You are right to refer to Richard Nixon. Richard Nixon considered that if he were to challenge the election, even though the 1960 election turned on less than 80,000 votes, that it would affect the credibility of the presidency. He felt it was important to preserve the presidency from the potential delegitimization that would arise from an undue challenge. You know, an election is about the majority of votes. I think that this is something that people should recognize, and people need to recognize that you can lose the majority of votes. The problem we have in Nigeria is that the courts have given credence to the idea that on any number of technical grounds, the will of the people expressed at the ballot can be upturned. It's happened in many cases. In that case, political gladiators are encouraged to go to court and to look for the slightest, the most arcane legal or technical point to raise in the hope that the courts will give them authority to take the people's mandate. This is a misconception of the role of the courts. It is damaging to the credibility of the courts. It is damaging to the efficiency of the system of justice because, as Mr. Falana rightly pointed out, civil cases, criminal cases, which are the ordinary fare of courts, are disrupted when thousands of cases are brought before judges who are then uprooted from their ordinary day-to-day jobs and are asked to decide election petitions. It is not the job of judges to decide the winners of elections. The challenge of INEC is logistical. The people's voice should be heard by counting their votes. The task of INEC is to create a logistical system by which those votes can be collected and can be presented in a way that will be favorably viewed by those, even those who have lost. In any dispute, if an impartial arbiter is administering a dispute, the test should be what the loser thinks. If the loser has no reason to complain, then the system has succeeded. This is the problem. So it's not for the courts to decide, but the challenge remains for INEC as the administrative body to improve its logistics and legal framework so that people will walk away knowing that they have been heard, but the people have decided. This is really the test.
Well, indeed, I mean, that is simply the test. If INEC had been able to conduct elections in a manner that was acceptable to all of the parties, I doubt very strongly. I do not know if you think that we will not go to court, and I don't know if you see a day first? Maybe that's one thing to say. Do you see a day where we will be able to conduct elections in this country and there will be no reason for political parties and politicians to go to court? Do you think that day is anywhere anytime soon?
You know, in any election, somebody's going to be disappointed. This is the fact. And disappointment is not a reason to disrupt political activity and the process of governance by bringing a challenge. Not every challenge has merit. Not every challenge has substance. I mean, we've talked about the examples in foreign countries. The idea that you can bring any challenge, no matter how remote, no matter how technical, before the courts is what lends credence to this disruptive behavior. And I consider it disruptive. To be fair, it's a good opportunity for lawyers to earn money. But earning of money is not the purpose of the justice system. The purpose of the justice system is to regulate all areas of human activity in a way that promotes the safety and the progress of society. So in the present case that we have, you talk about a presidential election petition. There are important things that Nigerian people need to be done on their behalf. The work of governance is important. Politics is about creating solutions and solving people's problems. If a government is fighting for the next 2 years or even the last 18 months, a crisis of legitimacy imposed by petitions which have a very slight chance of success, then that is unnecessary disruption, and the courts should not encourage this. But let it be said, INEC can improve, and it ought to improve. The complaints of individuals, even if they've lost an election, is valid because it allows us to concentrate on the efficiencies and the effectiveness of the system of conducting elections. That is important. But however, it's not every case that parties should feel they can roll the dice, and maybe some judge or some group of judges will be favorable to allowing a technical ground of turning the people's will.
It'll be interesting to see, just how matters proceed. And some people will always say, well, it's always better for politicians to approach the court than to take matters into their own hands or to encourage their supporters to take laws into their own hands when they feel hard done by. But I want to, look at the Supreme Court judgment itself. Before the court cases started, I think we had invited you on the program and you had given us your own analysis of what you thought might transpire in the court and what grounds of appeal that the candidates and the political parties might have. But looking at what has transpired at the highest court in the land, would you say that the judgment that has been given on the substance of the matter, or would you say that they have been given mostly on technical grounds?
I would say that in this case, the judgment has been given, well, the challenges that were made were largely technical. So, of course, the court has to resolve technical problems, technical questions. I do not see in any of the petitions a case made that the petitioner won the majority of votes and satisfied the Electoral Act for complying with the right to be declared as president. The substance of this petition was as to interpretations of the Constitution, over 25% in Abuja, questions of the qualification and the competence of the individual candidate, in this case, the president of Nigeria. So I think, and this is consistent with what I said earlier on, the idea that the slightest and the most arcane technical point may be brought and may have a chance of overturning an election is very dangerous. The question a court should ask itself when faced with an election petition is this: what is the purpose of this election? The purpose of election is to determine how the majority of people have voted. This is the issue. And the principle should be that whoever has the highest number of votes should be declared the winner. I've seen cases in the past where the person who won the highest number of votes has lost the election in a court case to somebody who didn't. That is anti-democratic. This undermines public confidence in the democratic process. Because people have to understand that if you lose an election, you try another day. This is normal. But the idea that you may find solace in the courts on a ground which is not questioning the will of the people, but rather some construction of law, I think is dangerous. And this is a problem that I hope that the clarity that comes from the number of decisions we've had over the years, including the present case, should remove certain technical questions from contest. And people should say, well, there's no point in raising this point. The Supreme Court has decided it. And that's the point. And to go back to the point you made earlier on, election petitions are part of the electoral process. They're contemplated within the electoral law. And it is indeed an investment in steam control. Because after a disappointed party loses an election, it is better for him to go to a legal process. And that legal process, even by the time that it takes, allows passions to cool, allows people to consider the better interests and their better judgment as to what to do. So I think it's very important to allow that opportunity. But I think that the disruptive effect on our politics, the disruptive effect on our ordinary day-to-day administration of justice is not tolerable or sustainable.
While it is, I think a number of people, I mean, maybe a majority of people, as a matter of fact, may agree with you in terms of, you know, how matters need to be decided on whether or not it is the will of the people. I mean, the will of the people was represented. Doesn't that also place like a very big burden on political parties to be certain of the candidates they are presenting, given the steep consequence they might pay if their candidates are found unworthy by even their own qualification? Isn't that what we've seen so far in terms of the emphasis laid on qualification, laid on you know, whether or not they were suited in the first place, whether they met the criteria as stipulated by law?
Yes, you're right. Political organization has failed in many of our political parties. The process by which candidates are selected does not appear to be one that will bear much scrutiny. It appears that from anecdotal evidence that there are many reasons beyond qualification, including corruption, including various sentiments, ethnic, religious, whatever. There are a variety of grounds on which candidates are chosen or preferred, which diminishes the obligation of parties to clarify the qualifications, the background of their candidates. You know, it's a responsibility of a party to present a candidate who is qualified, and it's their job of their internal organization to achieve this. It's also the job of your opponent to do opposition research and to determine well in advance of the election who he's going to face and what are the likely weaknesses in that person's qualifications. But then, once those things are exposed and ventilated, if a person is qualified, then questions about character, questions about the recent presidential election raises questions about whether a person was qualified by certain university or whether he went to certain school. If somebody is of weak character and the opposition exposes this weak character, even then, it is for the people to decide. If the people want to appoint somebody who has a tendency for dishonesty or for other types of misconduct, that is democracy. As long as they're not prohibited by law, which is the task that the parties must achieve, and they have not been doing to this time, then the people must be allowed to choose their candidates regardless of their character.
You know, Mr. Johnson, that this matter of the people, a lot of people will still be wondering at what point the people's choice really comes to play. Because you said something earlier that the role of the courts or the role of the judiciary in our electoral process is already contemplated in the course of setting up the electoral laws. So if that role is already contemplated, how well has it affected the perception of the courts or the judiciary in terms of negative or positive? Because if we look at our electoral process so far, it's been like the will of the people has been put to the corner.
You know, in the 2000 American election, this, as you know, this was highly contentious. This is the Bush-Gore election. The famous quotation from Justice Breyer in that case, Bush v. Gore, is that people may not know who won the presidential election of 2000. He says, but they won't. What is known is that the loser in this 2000 election is people's confidence in the integrity and impartiality of the judges to decide their disputes. So it's a problem. When judges get involved in party political matters and even in election matters, which are not party political as well, their reputation is threatened because it is a field in which nobody's going to accept the outcome. Who are you, Justice X, to tell me that in Kogi West or in Oshobo South, we didn't win the election? We know we won the election, and that's all. And people are not going to accept the result that the judges give. The result that has to be accepted is the one that is demonstrated with force. I don't mean physical force, but I mean with compulsion on the ground. So this is the test. Again, to reiterate, it's not for judges to decide elections, but systems must be created, must be sustained, maintained, and we must work to create better systems which give us the assurance that the result that comes from the electoral umpire is one in which we can have confidence.
Well, talking about better systems, one of the innovations that was introduced in the 2023 elections, and a number of people were very optimistic. It wasn't just one. I mean, there were about two major, areas of technology introduced, not just in the Electoral Act, but also in terms of what INEC did. The BVAS technology and also the IREV portal, which was supposed to entrench and engender transparency. And we saw what happened with the IREV on that day. And that was one of the grounds which, the respondents went to court. Or like I said, the litigants now went to court. And the Supreme Court had to rule on it. And they decided that the unavailability of election results on the IREV portal was not a ground to cancel the election. I think Justice Okoro ruled extensively on that. He said it was disappointing, and of course it makes the elections less credible. Truth be told, he said, it makes the elections less credible, but it was not a ground for the cancellation of the results. Does it take you back in any way to 2015, where we had the card reader, and the card reader, even though people saw there were some improvements in many areas, but in some other areas, they saw irregularities. They could see that as a result of the introduction of the card reader, the irregularities which some politicians tried to, put in the system were exposed. But because there was no law in the in our Electoral Act back then, backing the card reader, very little could be done by way of achieving justice, in quote. Do you see any similarities here between, even though now INEC is allowed to use whatever means it wants to use, electronically speaking, to conduct the elections? Do you see any similarities back then in 2015 and what transpired in the 2023 elections, especially when you look at the Supreme Court judgment on the use of the IREV?
The Supreme Court judgment is correct. The validity of an election is not affected under the Electoral Act by failure to utilize these advantageous technologies to which you have referred. It's the same thing in 2015. The court held that the card readers were not mandatory for use under the electoral law. I think that it may help. The purpose of IREV and BVAS is not to count votes, but to improve public confidence in the system of elections. And that is important. This is a major task. As I said earlier on, if the people accept the integrity and the efficiency of the electoral umpire, then they are more likely to have less reason to challenge election results. But at the end of the day, the primary evidence of an election result is the result sheet taken from every polling unit. IREF promised that those result sheets would be available to the public in real time. BVAS promised to verify the identity of those who would cast those votes. These are two measures that are important and by which technology will improve the credibility of our elections. But at bottom, nobody can, well, you can destroy paper, but if each party does its job and has representatives, polling agents at each polling unit, which each party boasts to have, especially in a presidential election. Now, the logistical problems, the logistical undertaking of a presidential election is huge. Then the paper is the primary result. If you don't have the IRF publishing election results, your agent should have the result. So this is the primary purpose of that election result. We know what happens on the floor. All that IRF does is to broadcast to the world simultaneously what has happened. It's like somebody dying and you say, he's not dead until I've seen the obituary. They're two separate things. But then you're right. In 2015, the legislature had not made provisions to encapsulate better technology which would have improved the quality of our elections. And in 2023, they have not done so still. So we hope that the lessons from this election result and from the judgment in the petition, it's quite scathing for the court to say it doesn't apply, but then that's disappointing for the result and the credibility of the elections. So I hope that our legislature is listening, and if they're doing so, then they will modify the law to improve the measures, especially those that are available by technology, to improve the credibility of our electoral process and the result that is produced at the end of the day.
What you just said now continues to reverberate in my mind, particularly in the light of a word you used earlier, delegitimization. And that perhaps has also thrown up another conversation altogether in the entire process. A good number of people are saying, senior advocates such as yourself included, are saying that, look, what if we conclude all issues around this before we swearing anyone? I think it was even Professor Awakalu Eseyan who said, look, was it him or someone else said something along the line of, look, let's see it as a competition. You don't get a prize until the entire race is completed. So that's the way one of your colleagues in the inner bar also put this. So would you also go with those who are thinking that perhaps the National Assembly should consider that all processes be concluded before anyone is sworn in, especially at the presidential or gubernatorial level? Some are proposing that all litigations be concluded, maybe we'll have elections maybe 10 months or even 6 months before May 29. And then after that, after whatever it is, all litigations are concluded before May 29 of the election year, and then the winner can be sworn in. What do you think?
It's an attractive proposition in some way, but we have to recognize that one of the problems with elections being indeterminate for a long period of time is political instability, economic instability. There's a danger in a process which creates a vacuum in the executive authority of any country. So if you look at other examples, Kenya is a country where the election dispute was decided very quickly before the president was sworn in. Of course, if you look at the petitions raised there, they are highly organized, the legal work has been done well in advance, and they are attacking specific issues which allow the court to decide very quickly. In America, you will recall in 2000, the Supreme Court stopped the counting in Florida because it would disrupt the schedule, the constitutional schedule for appointing a new president. They were not going to allow disputation over the number of votes, the hanging Chad, the separated Chad. The veracity of the numbers in Florida in 2000 was sacrificed because of stability and because of the progress of the nation. This is what is important. So you have to recognize that what a result, getting the result in the quickest possible time is getting the highest quality result is not always the most important factor. You have to think of bigger factors. I mean, people have obsessed about time this time because this election was so decisive, and many of the proponents of one candidate or the other felt that there was some advantage to be gained by preserving the continuity of executive governance in Nigeria. I think that where the balance is to be struck is something we would have to work on. I think it's important that there should not be a vacuum in power. And I think it's important that lawyers, I think Chief Clark said this as well a few days ago, the lawyers who do election petition cases have a lot of work to do. They have to prepare well in advance. And I'll give you another example, which I've given many times. Because the 2000 election in Florida decided the presidential election, in 2004, the Democratic Party, ahead of the 2004 election, sent 500 lawyers to Florida alone, 6 months before the election. Because you have to prepare, you need the foundation. You can't get up after an election. You don't know how many agents you have. You haven't seen the polling results. You get a couple of lawyers together. Some are your friends, some are not your friends. Some have done elections before. Some don't have the logistical capacity. You cannot make a cake that is good to eat with poor ingredients. So at the end of the day, I think that the work of challenging election is so logistically taxing, not just legally taxing, that better preparation needs to be made even by those who would challenge elections. It's not a surprise that most election petitions do not succeed.
Well, you know, something that you said also brings this same question or this point that is being made by some senior advocates of Nigeria, including Professor Awakalu and Mr. Kunle Adigoke to mind. Even Mr. Ebonlu Adiboro added his voice to that. The input or inclusion of technology. One would have expected that with technology in the mix, everything would go, okay. But then you also find a situation, and I'm glad that you mentioned what the Supreme Court said. I mean, what the entire judgment of the Supreme Court revealed, that it is not about whether or not the winner got the highest votes. You talked about the fact that it's largely on technicalities. And that's essentially saying, maybe we can say that the election itself went the way it ought to go, but the technicalities around it are a little more cumbersome. How do you think we can win that? Because that is essentially saying it is the politicians that are interested in ensuring that while the votes are there, we can go to court and make issues where there may or may not be issues. So is it a problem with the political class here, or the electoral system itself, or the people who are, at the end of the day, at the lower rung of the ladder, and whatever cases are raised at the courts largely delegitimize whoever it is that is elected?
First of all, I should say that technology can fail. In 2020, America used the most cutting-edge technology for elections, and still today, there are people who still deny the result of that election. So at the end of the day, in a political contest, some people will never accept. As to technicalities, I think that, again, the test is the number of votes. Who won the highest number of votes? Most election petitions, and this presidential election petition is a key example, the substance of the petitioners' cases were highly technical points which did not go to numbers. None of the petitioners claimed to have won the majority of votes. None of the petitioners claim to have won the required spread that the Constitution makes mandatory for declaring a person properly elected under our Constitution. So, if you bring a technical case to the court has to decide the legal question you put before them. The court can't, I think that, again, Justice Okoro quoted Justice Toby saying that the court does not go to the marketplace to search for evidence. If you have a case on facts, you bring a case on facts. If you have a case on arcane and technical questions of law, that's what you bring, and that's what the court will dispose. Again, to repeat myself, when you bring these questions that are difficult for the ordinary man to understand, it's easy for them to take the view that the election result has been forged. It delegitimizes the government. It makes the work of government and of an incoming administration more difficult. And this is something people need to discuss, to consider. To take the example you gave me at the beginning, Richard Nixon. Richard Nixon, who became president even though he lost the 1996 election, decided quite rightly, in the interests of his country, that it would not serve the interests of America for him to challenge an election, which he could well have challenged even on the numbers, because he had a commitment to the stability of his country. And he was rewarded subsequently with his own election to the presidency. So parties need to, I think that part of the problem with our politics is that people go to seek electoral office for private gain. I think that is the problem. If you recognize that political leadership is a sacrifice, then you do it tentatively, humbly, and with the desire that I have something to offer, and if it's not accepted, well, I will wait again. And the great leaders of the world have faced reverse, and they've come back to get a better result. But our politicians see the prize as something that is going into their pockets. And this perhaps explains the psychological attitude that they take to loss.
Well, it's a long conversation because this started long ago, and God knows how long it'll take. But this has been quite illuminating. Thank you so much for your time this morning. Sayemi Candidate Johnson is a senior advocate.
It's my pleasure.
Thank you so much for your time. We're back right after now to take on another issue. Do stay with us.